We will go on the record in the matter 25 CF 158, State of Wisconsin versus Luke Beechler. The state appears through District Attorney Kevin Schmidt in person. Mr. Beechler appears in person with counsel Joel Feliski. We're set today in this matter for a plea in sentencing. Mr. Feliski, can you please recite the agreement for the record?
Could we just wait 5 minutes? Because I think the victim will probably come.
Okay, then I guess we'll wait 5 minutes.
Sorry.
All right, we'll recall case 25 CF 158, State of Wisconsin versus Luke Beechler. The state appears through District Attorney Kevin Schmidt in person. Mr. Beechler appears in person with his counsel Joel Feliski. We do not have any victims apparently wanting to appear today. Correct, Ms. Bauer?
I don't see any.
But you're in victims' rights compliance?
Yes, Your Honor.
All right. So the parties have reached an agreement. Mr. Feliski, can you please recite it for the record?
Yes, Your Honor. The parties have reached an agreement here for Mr. Beechler to plead to count 1 in 25 CF 158 as amended to a misdemeanor OWI second, with count 2 being dismissed by operation of law. The parties will be making a joint recommendation for sentencing under the aggravated guidelines. My understanding of that being $1,711.50 in fines and fees, a 45-day jail sentence, a 17-month revocation of license, a requirement for an ignition interlock device to be installed in any vehicle operated by Mr. Beechler, along with a 45-day occupational wait period. I have reviewed and completed a plea questionnaire detailing this with Mr. Beechler. Your Honor, may I approach?
May. How many days jail did you say?
45 days.
It's aggravated guidelines.
I know, but I have blood alcohol content of 0.16, not 2022 or to 0.249. And if we do 0.16, it's 40 days jail, 16 months revocation. Tenth District Judicial District Guidelines for an OWI second, 0.16 or over 0.15, aggravated.
I must have just misaligned the lines when I did it. It's one higher, so it should be 40 instead of 45 days and 16 months. Oh, I'm sorry, wrong category.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. At first glance, this might look like a routine plea hearing, but don't let that fool you. The courtroom has already uncovered a crucial mistake in the proposed sentence, reducing both the jail time and the license revocation before the plea even moves forward. That single correction reminds us how every detail matters in court. But the real story is only beginning. A drunk driving crash, a seriously injured victim, and a defendant now standing before the judge to accept responsibility. Will genuine accountability influence the final sentence, or will the devastating consequences outweigh everything else? Stay with us because this case is about to reveal far more than just numbers on a plea agreement.
Yeah, 40 instead of 45 and 16 instead of 17 for the revocation.
Sounds like a better deal for you, Mr. Beechler. All right. That's the agreement you've reached, Mr. Beechler?
Yes.
May you please turn the microphone down? Thank you. Pleading guilty to an amended count of an OWI operating while intoxicated second offense. Is that correct?
Yes.
Formal motion to amend the OWI causing injury second and subsequent to a straight OWI second.
So made.
Granted. You're 37 years old. You have 11 years of schooling. You do not have a high school diploma or equivalent, but you can read write, and you understand the English language, correct?
Yes.
Did your attorney go over this document with you?
Yes.
Did he go over it thoroughly with you,
Yes.
essentially word for word?
Yes.
Did you understand everything completely?
Yes.
If there was something you did not understand, did you ask him to explain it to you until you did so?
Yeah.
Is that your signature on the second page?
Yes.
You are pleading guilty to that OWI fourth count. Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that first page of the plea questionnaire. Did your attorney go over those rights with you?
Yes.
And he went over them thoroughly with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that you're giving up those rights by pleading guilty?
Yes.
No mental illnesses or disorders, no alcohol, drugs, or medications in the last 24 hours?
No.
Because, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around November 2nd, 2025, that you operated a motor vehicle while under the influence of an intoxicant on a roadway or a highway of this county and state? Do you understand what the state would have to prove?
Yes.
You understand that this would be your second countable offense?
Yes.
You understand the minimum and maximum possible penalties? The minimum could be minimum of 5 days of jail, but no more than 5 days of jail is the minimum. 6 months of jail is the maximum possible penalty. Do you understand that?
Yes.
Or a fine not less than $250, but no more than $1,000. Do you understand that?
Yes.
Do you understand that the court is not bound to follow the recommendation that's been provided through argument or recommendation from the parties? Do you understand I'm free to sentence you to what I believe is appropriate, and that could be up to the maximum possible penalty?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney? And in particular, I'm going to say that probable cause section where it basically says what happened and why you were charged with the crimes.
Yeah.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty today because you are in fact guilty of that offense?
Yes.
Mr. Felisky, may the court use the probable cause section of the criminal complaint to find a factual basis with the statement made by Mr. Beechler?
So stipulated.
Has anybody made any threats or any promises to you for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
I am.
Do you have any questions for the court or for your attorney before I proceed?
No, I do not.
As to count 1 OWI second straight offense, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged in and dismissed. A judgment of conviction will be entered today. Is there, I forget if there's restitution, and there may be, that was settled with the insurance?
There's no restitution request. We checked with the victim. They did not want there to be a restitution request because in consultation with their attorney, they thought it might negatively affect how they get that somehow.
All right, I think I recall that's what you said at the last hearing. Okay, so Mr. Schmidt, argument and sentencing recommendation.
I'd ask the court to follow this recommendation. The defendant, his only prior history is his other OWI from 2021 in Mesa, Arizona. This is a case where the victim, his worst injuries were caused by being dragged under the defendant's car. According to the victim, he doesn't remember much. He just remembers that he had to be removed from underneath the car with assistance of first aid responders. and had pretty horrific injuries. That's kind of detailed in the victim impact statement. The defendant, his account was something like, he doesn't know how the victim got under there. He just did somehow. There was a witness at the bar where the victim was struck by the side of the road. He said that there was a second vehicle that first struck the victim, and then the victim got thrown underneath the vehicle of Mr. Beechler. Mr. Beechler did stop his car and get aid immediately. He also, while he was in custody, everything law enforcement went to him for like getting consent and looking at like phones, vehicle, etc., to try to find evidence of the second vehicle or locate who it was. He was aiding in that. We never did find the second vehicle. It's hard to say how much of this is Mr. Beechler's fault and how much of this is the first vehicle's fault. Mr. Beechler did do a good thing in when he did collide with someone to call the police and get that person help. On the other hand, Mr. Beechler was intoxicated and he shouldn't have been behind a motor vehicle and somebody did get harmed. Is it possible that even with those circumstances that this victim wouldn't have been harmed if Mr. Beechler was intoxicated? There are just things we'll never know in this case.
Now the courtroom shifts from determining guilt to deciding consequences. And this is where sentencing arguments often carry the greatest emotional weight. Notice how both sides acknowledge the same facts but frame them very differently. The prosecution emphasizes the devastating injuries, the defendant's intoxication, and the danger posed to the public, while also recognizing that he stopped, called for help, and cooperated with investigators. The defense, on the other hand, is preparing to focus on accountability, rehabilitation, and genuine remorse. That's the balancing act judges face every day. Punishment, public safety, and the possibility of redemption. What do you think deserves the most weight in a case like this? The harm caused, the defendant's actions after the crash, or his efforts to change? Let us know your thoughts in the comments, because the judge's final decision is coming up next.
For that reason, I think the aggravated guidelines are appropriate and I'd ask the court to follow them. Thank you.
All right, thank you. Mr. Felisky?
Thank you, Your Honor. I will first note the applicable credit here. Mr. Beechler appears to have 32 days of credit. He was brought into custody on this offense on November 2nd, 2025, and was able to post cash and was released on December 3rd of that same year.
It was already set the time. Good time. Sorry, I didn't mean.
No, I'm just reflecting on what I'd like to say, and I think I'll start out by saying that I grew up with alcoholism in my home. And I think that the thing people miss about alcohol in that regard is that it isn't just the physical harm, the mental unwellness, the behavioral changes that really impacts people. They do play a role. But when I was thinking about this case, the thing I was struck by was that when it comes to alcohol and alcoholism, for the individual that's suffering from that, it's a question of misery. It's someone who takes all the gifts that their parents give them, all the love and care their friends and family and community can provide them, and they drown it. They drown it in alcohol. They let misery win. And in my life, it kept winning and winning. And one day that person made a decision not to let it win anymore. And by that time, for some things, it was too late. But that was what made the difference. And sitting here today and speaking with Mr. Beechler and having spoken with him with this case as it's proceeded, I know that he has made the decision not to let misery win. He made that decision, as the state noted, perhaps from the get-go. He took accountability immediately. He got out of his car. He called law enforcement, knowing that they were going to be there, that he would likely be going into custody, that things would get very difficult for him. He made the decision to not let misery win when accepting responsibility here, when taking this offer from the state, when accepting up until, as the court noted, the aggravating factors, additional time in custody, taking accountability for having committed an OWI, taking accountability and responsibility for committing that sort of action by having his license revoked, by requiring an IID in his vehicle. He's taken accountability and responsibility here and has not let misery win by dwelling on this, by thinking on it and reflecting it. One of the most notable things I found about Mr. Beechler has been the degree of devastation and regret and contrition that he has shown stemming from this incident. It has truly devastated him. And in some ways, I think that's healthy. I think a terrible thing happened that night. And while Mr. Beechler perhaps was not the cause of all that happened, he is here and is ready and is willing to admit his part in what happened. In the time since this has happened, he has continued to not let misery win by working on getting his HSAD in the jail. I believe he's waiting for some paperwork to finalize and finish that process. He's been working on getting custody back for his son, and following the proceedings here today, following the resolution of this case, he does plan to return back to Arizona to continue seeking that custody. I think looking at the galleon factors here, Your Honor, this agreement is appropriate. It protects the community. The community has been and will continue to be protected by these deterrents, by these requirements that Mr. Beechler will be required to follow through on. I think it's appropriate given the nature and gravity of what happened here. And I think looking at his character, perhaps most importantly, Your Honor, I believe this experience has truly changed him. It's regrettable that this is what it took, but it has changed him, and in some ways it's changed him for the better. He's been able to refocus on what truly matters, which is his family. He's kept himself busy and occupied through employment at 2 different jobs. He has been working on his hobbies, finding better ways to express himself and to work through stress without drinking alcohol and getting behind the wheel of a vehicle. And perhaps the other thing that has really struck me about Mr. Beechler is his focus on the victim. Every opportunity that it has come up, every time it has been mentioned in our conversations, he's expressed nothing but regret and shame for what happened. In fact, several of the first times that we met and spoke together, he started out by asking, is he okay? How is he doing? I think that says quite a lot about his character. I think that says a lot about how he has thought about this process and what happened overall. And I think that it is very indicative that this is not going to happen again. Overall, I think under the galleon factors here, I do think that this agreement is appropriate, and I would ask the court to follow it. Thank you.
Thank you. Mr. Beechler, is there anything you want to add or you want to say to the court?
Excuse me. I know that Jackson and his family aren't here, but I wanted to take accountability for the decisions that I made and tell them that I'm deeply sorry for the pain and trauma that I've caused them. And that I'm going to do everything that I can to make sure this mistake doesn't happen again. Thank you.
Right. That was a very profound and touching argument, Mr. Flisky.
Thank you, Your Honor.
Operating while intoxicated cases are very serious, and in this case, you can see why. Mr. Beechler, this was a case where you were over the legal limit, twice over the legal limit. You were operating a motor vehicle, not just operating, you were driving on a road or highway of the state and county, and you hit a human, and the human was seriously injured. On the other side, you were the second car to hit that human. Had the first car not hit Jackson, perhaps you would not have hit Jackson either. There's no way to tell. If we could go back in time and we can change some things, I know we would, but there's, as Mr. Schmidt stated, there's no way to determine the percentage of your fault in Jackson's injuries or the phantom car who was never caught, their fault in Jackson's injuries. But everybody does agree there was another vehicle. They just weren't able to determine who it was that was driving that vehicle or the vehicle itself. But you're standing up and you're taking responsibility and you're being accountable for your actions, which is a positive thing. Not easy to plead guilty to a crime, and it's definitely not easy to plead guilty to an operated while intoxicated offense, because in the state of Wisconsin, once you get your 4th lifetime revocation of your driver's license, and that's a big deal. When you live up here, you live where we do in Wisconsin, you need a driver's license. It's very difficult to be dependent upon another person or other persons to be able to get you anywhere you need to go. It's, nobody says otherwise that this is a serious offense. Hopefully you're doing better and you understand things better, and you're going to do things differently the next time. At this point, you don't seem a risk to the community. I don't have any bail jump violations. This goes back to November 2nd of 2025. I have no indication that you are breaking the law or doing some things and not understanding the seriousness of your conduct that day. It's a positive thing, and it's a good thing that I heard you say, my mistake, the mistake, instead of the accident, or it was an accident. It was not an accident. Did you intentionally mean to hit Jackson? No, but you intentionally got into a vehicle while under the influence of an intoxicant, of alcohol. That was intentional. You knew what you were doing there. It had serious ramifications, more serious than some normal run-of-the-mill OWI, but it wasn't an accident that you operated while intoxicated. I believe that you've shown the court that you've been doing a lot to improve yourself, to educate yourself, to have some personal reflection, and to take accountability. So the court will follow the recommendation of the parties at the above 0.15 blood alcohol and aggravated driving. $1,680 in fines and fees with a $10 blood draw fee, 40 days of jail, 16 months of revocation of your driver's license, 16 months of ignition interlock device installed in your vehicle. I will order the OWI AODA assessment and all of the follow through. I will also give you credit for any administrative suspension that you may have already received. You have 32 days of jail credit, and you sat that all up front, and you got a huge penalty in the beginning when you were arrested. You had plenty of time to think about your actions and the consequences of your actions while you were incarcerated. With good time, you do not have any other time to sit.
What a powerful conclusion to a case that was about far more than a single guilty plea. Throughout this hearing, the judge made one message crystal clear. Choosing to drive under the influence is a decision, not an accident, and that decision can permanently change innocent lives. While the court recognized the defendant's acceptance of responsibility, cooperation with law enforcement, and genuine efforts toward rehabilitation, it also emphasized that accountability must come with meaningful consequences. The final sentence balanced punishment, public safety, and the opportunity for personal change, showing how courts strive to protect the community while encouraging rehabilitation when appropriate. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, legal insights, and dramatic case analyses. Thanks for watching, and we'll see you in the next courtroom story.
We do have significant cash posted for you. The fines, fees, all of that will be taken out of the cash bail. The remaining will be returned to whoever posted it. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I am going to order that you provide your DNA. So you're going to need to go to the jail when we're done here today to ensure that they have your DNA. You have the right to request it be expunged from the system through a written letter to the Wisconsin Department of Justice, not to this court, to the Wisconsin Department of Justice. It's easy to do. You can Google it or ask Mr. Flisky. He can help you if that's what you want to do. I believe that covers everything. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Flisky.
Nothing further.
All right, thank you. Then we are adjourned. You need to come up here and get a form to go to the jail.
Hey, Your Honor, I am going to go grab Mr. Java. I have him at the office. I had to meet with him anyway today. Give me just 1 second and I'll be right back.
No problem. Thank you.
Yep.
All right, is he with you now?
Yes, do you want me to just have him pop back so you can see him quick?
Yeah, yes, or scoot
Okay.
closer to you so I can see both of you.
Okay. Yeah, you can pull it up right there. It's totally fine. I'm just gonna minimize everything else. There we go.
All right, we will go on the record in the matter 24 CT 30, State of Wisconsin versus Ethan Java. The state appears through, well, we don't have the state, what we do through probation agent. What's your full name?
Abby, Abbie, last name Ausen, Aasen.
Thank you so much. This is
Yeah.
the first time I've interacted with you, Ms. Austin, so thank you very much. And thank you for spelling it for the record for my court reporter.
Yeah,
We're
no
here
worries.
today for a probation review hearing at the request of Ms. Austin. Mr. Java appears in the same office by video conferencing with his agent, Austin. Ms. Austin, you requested this probation review hearing, and I'm going to be honest, I don't know why, because I don't have a letter in my file. I don't know why it was requested.
Sure, my apologies. Moving forward, I will send a memo up to Burnett County. I haven't really dealt with Burnett in really any other context. And normally I don't send memos to my court unless I'm requesting something with an order. So I just called this probation review hearing. Mr. Java has truthfully been a great client to work with. I haven't really had any issues with him. He's had no violations in the past year. The only thing is that he does not have his driver safety assessment and follow through complete. I know that he's maintained meaningful employment. He's been able to move out of his brother's into an apartment style living, which has been more beneficial to him. He's able to split rent, stuff like that. But with obviously living in a more expensive area, and combined with making payments to the court, which I don't think is a bad thing, finances are tight. Our assessments here, just the assessment alone is, I think, a little over $300.
Long and the short, you're going to ask to allow him to discharge without having to do that, correct? Is that where we're going?
No, I was going to ask if he could be extended. I just wasn't sure
Oh.
in what increment you guys would want him to be extended in, whether that's
Okay.
6 months or a year, and if the court would allow him to pause on his payments just to get the money to do his assessment.
All right, that makes me feel better, Miss Austin, sorry. And that's why I like memos. I don't know what they do in Pierce County or other counties that you appear in front of. I like a memo so I can be prepared to have an idea of what you're asking for and why you want the hearing. Because quite honestly, I'm like, okay, what has Mr. Java done? Has he driven now without his driver's license?
No.
Those things. That's all good to hear, Mr. Java. That makes me so proud of you.
Thank you.
Because I want him to get his driver's license. I'm gonna be quite honest. I was getting sick of seeing his face in my courtroom.
Fair
And
enough.
that's in a funny way. Yes, because he would come here and then he would leave, he'd post bail, and then he'd go and he'd drive again and he'd be back here and he'd post bail and he'd do the same thing. I want him to get his driver's license. And I know he wants to do that as well. So I am comfortable. I don't care if we extend for a year, we extend for 6 months. And my thought is as soon as he gets his driver's license, I'm okay with him discharging immediately. I want him to get his driver's license.
Okay.
So if you want to just extend for 6 months and see if he can do it within 6 months, that's great. You want to extend for a year and have in there that the court stated that I'm only extending it to as long as until he gets his driver's license. I'm cool with that too. I want him to get his driver's license. I am also prepared to I'll give him a few months of stay of payments for his fines and fees. Because to me, that's worth it for him to be able to pay for his OWI, AODA assessment and do all of that follow through and to pay to reinstate his license and the ignition interlock device and all of those things. So I will give him a stay until September. First payment back will be September.
Okay.
And if we need longer, if you need any longer, Miss Austin, I don't need to have a probation review hearing to be able to do that. All I need is a memo that lets me know he's been doing what he needs to do. He's been able to save some money. He just isn't yet able to get his license. Can he have a stay for a couple more months? Something along that lines. And then I can just stamp it and go, yep, I agree. I don't see why I wouldn't agree, but if I didn't agree, I'd just say, nope, denied for whatever reason I find to deny. But I'm all with you, Miss Austin, and I'm all with Mr. Java. I want him to get his license as quickly as he practically can.
Perfect. I will submit the 37A and I'll put on there with acquisition of driver's license. Cause I mean, realistically, the assessment and the follow through are going to have to be done anyway for him to get his license. So yeah, I'll prepare that order. Is there anything else that you would need from me for the court?
I don't think so. Is he paying, you're paying, Mr. Java, you're paying the court fines and fees and payments here, or you're just paying DOC?
I believe I'm sending him to Burnett County.
Yes.
Well, my clerk is saying that we're seeing that you're in our state debt collection. So are you making payments every month?
I haven't missed, or I missed last month, but if I'm in the debt collections thing, that would explain it. Is that like wage garnishment or?
It could be, and I'm not in control of that. What I would need to do then is talk to my court clerk, my head clerk, and see if we can pull it back from state debt, because it sounds like you already have an agreement and you work things out with state debt collection. And if you're making payments and you missed one, you're paying the state debt collection, not to the court. And so what I can do is I can double check on that. And if we can pull you back, I'll pull you back, and then I can stay you until September and we can go from there.
Okay.
But then I'm going to tell you, I'm not going to let you go to state debt anymore, because then I'm going to have my own financial review hearings and I'm going to make sure that it gets paid, because that is part of the punishment, quite honestly, for the crimes that you committed. But I'm willing to work with you right now for sure.
Perfect.
Okay.
Good.
Yep, that sounds good.
All right. Thank you.
Perfect. Thank you, Your Honor.
We're